Well, hello, everybody. This is Lillie Dominguez with Agent Prep coming to you today so that we can review national and Texas questions. So I'm going to review questions and answers from a book that I have that I'm going to show you right now. So if you're struggling to pass your real estate exam or you're failing, then you need to listen to these questions for national and for Texas. So this is the book that we're going to be using, and you can purchase it on Amazon, and I'm an affiliate, so I'll get a commission from Amazon. And it doesn't cost you anything other than purchasing the book. So this was published in 2024. So it covers all the new contract issues and, of course, national. It has national and Texas questions, reviews all the information that you need to know to prepare for your national and your Texas instead of reading all your different books. So once I start the questions, I would love for you to participate. Type in the question number and the letter answer. And should you get it right, I'll say Yahoo! Or I will explain the answer should you get it incorrect. All right, so let's start. We're continuing from a video that I did last year. And it's on, we're starting with question, what is it here? 231. Okay, and this is on chapter 2 of national, which has to do with encumbrances, liens, title transfers, and recording leases. And so during this, I'll be adjusting the screen, okay, to in order to fit the whole question in the screen. All right, so a municipality wants to build a sewer treatment facility, which will require the acquisition of several parcels of private-owned land. What legal power enables the municipality to buy the necessary properties, even against the owner's wishes? A, estoppel. B, escheat. C, alienation. And D, eminent domain. So here you have 4 vocabulary, right? And you know those, you would be able to answer the question. So I'll give you a moment to answer the question on the chat. I tried to go live also on Facebook, and it's not quite working for me. All right, the answer here, so you can answer it on the chat. The answer here is 231D, eminent domain. So eminent domain is when the government can take property for public use. And of course, they do have to pay the current market value. If the owner doesn't agree, then the owner has to do an inverse eminent domain, inverse possession of that property. All right, any questions? So remember, type the question number and the letter answer in the chat. And bear with me as I adjust these screens, okay, so that I can show you the complete question. Okay, number 32. An adverse possessor must be able to successfully demonstrate that he or she has been what? A, openly possessing and claiming the property without the owner's consent. B, occupying the property without an occupant permit. C, using the property intermittently and without permission over a period of years. Or D, building a permanent structure on the property. So adverse possessor, that's a definition, okay? Vocabulary, intermittently, okay? Permit, structure, owner's consent. So to be an adverse possessor, they must be able to successfully demonstrate that he or she has been what? Type your answer in the chat. So the answer here is 32A, openly possessing and claiming the property without the owner's consent and also without interruption in the use of the property. So they can show a claim or right of color of title as a reason for the possession. They have notorious possession. In other words, they could be like a squatter. However, the owners never said anything, never kicked them out or didn't see them. So which is the possession without concealment. So their possession of that property was not concealed. The owner could have seen it if they had gone back and checked out on their property. And it has to be a consistent claim of hostile possession. And hostile possession doesn't mean that they're going and fighting, creating problems for the owner. Hey, they're just there without owning the property like a squatter. But the government will allow them to own the property if they do it for a certain number of years. In some states, it's 10. And so the claim of ownership and possession, regardless of the owner's claims or consent, occupying the property continuously. So they have to do it for the continuous period, if it was for 10 years, for a statutory period of time. In some states, they may pay the taxes. So that would help them out. So I saw a movie where this happened and a builder wanted to kick out this tenant that had been there. They weren't a legal tenant. They were a squatter, had been there for 17 years. Well, it came down to that individual ended up winning the property in the court. And it was worth multiple millions. So this squatter quickly became a millionaire. And I'm not saying you should go and do that, of course. This person was a homeless person that did that. You can see sometimes movies where they show that. All right, number 33. A buyer has signed a contract to purchase a property, but is uncertain of the condition of the title. Which of the following parties is legally responsible for knowing the condition of the title? A, county recorder. B, seller's agent. C, the buyer. Or D, the mortgage lender. Type your answer in the chat. Oh, I can't increase the screen here if I want to see the chat. Let me see here. I was trying to enlarge my screen. Okay, so the answer here is C, the buyer. So the buyer has to do their due diligence in order to know whether there is any conditions on the title, any liens, any judgments, property taxes that are owed. They want to do their own due diligence. But the seller will has to prove at the title company once there are, it's a contract, that they are the owner. Fee simple. If there are any debts on it, property taxes, any loan, they will be paid during escrow. So it has to be a free and clear property that is conveyed from the seller to the buyer. But the question says a buyer has signed a contract to purchase the property, but it's uncertain of the condition of the title. Which of the following parties is legally responsible for knowing the condition of the title? Well, the buyer is. However, the seller has to prove. So the buyer with their agent should ask for a title search on the property. So that was 33C. So I invite you again to comment on the chat box your answer so that I can help you if for some reason you have it incorrect. All right, number 34. A break in the chain of title to a property results in what? A clouded title. B, a title plant. C, a lien of indeterminable ownership. Or D, a duplicate title. So a break in the chain of title to a property results in what? All of these are vocabulary: clouded title, indeterminate ownership, a lien, a duplicate title. So for that reason, I stress studying vocabulary every single day. The answer here is 34A. It becomes a clouded title because there was a break on the chain of title. Maybe there was a deed in, not a deed in lieu, but there is information missing from the title of when it transferred from one person or another, or there's liens or something like that. And the only way to find out is to go to the courthouse or to go to a title company and pay for a title search. Attorneys do not do title searches. That's what title companies are paid to do. That is their expertise, to do a title search. Number 35. Wayne and Leota obtain an insurance policy that protects them from liabilities and losses resulting from title defects. The kind of policy they bought is a what? A homeowner's insurance policy. B, a standard owner title policy. C, lender's title policy, insurance policy. Or D, private mortgage insurance policy. Those are all vocabulary: private mortgage, lender's title insurance, title insurance policy, standard owner. Those are all vocabularies that I point out on here. So what is the answer? Type your answer in the chat, the letter answer and the question, the letter question and the answer letter. So the buyer here will want to ask for a standard owner's title insurance policy, which is B. So Wayne and Leota obtain insurance policy, which they get from a title company that protects them from liabilities and losses resulting from title defects and clouded title. What are title defects? A lien, property taxes, judgments, child support, spousal support, mechanical lien. All those are title defects. Or a name change that wasn't recorded. People get married, get divorced. There are name changes. Number 36. All right. An owner transfers title to a property to a buyer in exchange for a motorcycle. This is an example of what? A voluntary alienation. B, involuntary liquidation. C, hypothecation. Or D, a 1031 exchange. All of those answers, vocabulary. So get me. Study your vocabulary. You will be able to answer a lot of these questions. So the answer here is A, voluntary alienation. So the owner is voluntarily alienating transferring, exchanging their property. They're giving away their not giving away. They're doing an exchange, okay, of the property for a motorcycle. Some motorcycles are quite expensive. So it's voluntary alienation. Not familiar with that? Go back and study it or Google it and get a quick answer there. Number 37. A person wishes to convey any of the interest, any and all interest in a property to another without assurance of the property's marketability. This party would most likely use which of the following types of deed? A sheriff's deed. B, a special warranty deed. C, a partition deed. Or D, a quitclaim deed. Do you know what all those types of deeds are? So a person wishes to convey any and all interest in a property to another without assurance of the property's marketability. Okay, so they're not checking into how it's going to sell or if there are any liens or anything like that that would prevent it from going to someone else. So what kind of a deed would they be doing? The answer here to 37 is a quitclaim deed. A quitclaim deed is the lease, has no protection, no warranty, like a special warranty deed or a normal general warranty deed, which there is insurance by a title company if the buyer requests it. A sheriff's deed is where it's sold at the courthouse because they owe money on that property or their default on property taxes, their loan, or other liens. HOAs can also cause it. A partition deed, it's used by developers when they own multiple properties and they're partitioning the property into multiple deeds. Special warranty deed is when someone sells their property, like the administrator or the executor, they don't know the history of the property, so they were assigned to sell the property. They offer a special warranty deed. They don't know about all the past and the history, which would be included in a general warranty deed. Number 38. Ooh, that didn't work, did it? I would like to become an expert at this screen. All right, 38. Jennifer owns a 1/2 interest. What is that? 50%. In a condominium as a tenant in common. What kind of ownership? Tenant in common. With her business partner. With whom? A business partner. So she owns 50% as tenant in common because she has a business partner. Jennifer has several heirs and dies without a will. The property will what? A, pass to the heirs by law of descent and distribution. B, escheat to the state. C, pass to the surviving spouse based on homestead law. Or D, pass to the surviving heirs according to the provisions of the will. Now it says dies without a will, right? Intestate. Type your answer in the chat. No participation. So those of you that are viewing, hey, it helps. The answer here is A. It passes to their heirs by the laws and descent and distribution. So since there's no will, it's going to go to the court and the probate. And the courts will decide, the judge will decide who it's going to, because the individuals did not leave a will. Now, for someone to prevent going to court, in addition to the will, they want to have a trust, which details the outline of all that they own. It's a little more expensive. However, it prevents family having to wait and for the probate court. Number 39. A drifter secretly lives in an abandoned shack on a large ranch property. After 20 years, after how many years? 20 years, right? There's a statute that says they have to be there for a certain number of years, depending on the state. The person makes a claim of ownership to the shack and the land immediately surrounding it that he had cleared. In other words, this person is maintaining the land and that shack that he's living in, he or she is living in, the drifter. So this claim will likely be what? A, upheld through adverse possession. B, upheld because of length of possession. C, declined through the doctrine of prior appropriation. Or D, declined because possession was secretive. Remember, adverse possession cannot be secretive. It's like we don't want to be secret agents once we become realtors. We want to let everybody know, right? So in this case, it says what? A drifter secretly. That's the key word here, secretly. So they don't want to be secretly using the land if they want to end up taking rights of it. So the answer here is D. So his right to claim adverse possession was declined because possession was secretive. What kind of possession? Secretive. It cannot be secretive if they're going to accept the adverse possession and be awarded the land. Any questions so far? So we're going to do about 20 questions here. So we've done 9. It's been a while since I did it this way. I've experimenting with different ways of helping you learn the material. Number 40. To be marketable, in order to be able to sell it, okay? The title must be what? A, insured. B, free of undisclosed defects and encumbrances. What are undisclosed defects? What are encumbrances? C, abstracted by an attorney. Or C, guaranteed by a title certification. So I made a comment earlier that attorneys do not do title searches. So that's helping you a little bit on this. It will not be the answer C. Attorneys do not do title searches. If they do closings, however, if the buyer requests a title search, it'll be done through a title company. So to be marketable, what does the property have to be? It has to be free and clear. So free of undisclosed defects and encumbrances. What are encumbrances? Anything that creates a cloud on the property. It could be a boundary issue. It could be unrecorded well or septic tank that is being used by both neighbors, that are shared. All right, so number 41. Which of the following types of leaseholds, so what does it say? Leasehold estate lacks a specific term, because leases have a start and a beginning, just like contracts. So A, estate for years. B, estate from period to period. C, estate at will. Or D, estate by entirety. So which of the following types of leasehold estates lacks a specific term? So you have estate for years, estate from period to period, estate at will, and estate by entireties. Do you know what all these types of estates are? So at will means they can do it whenever they want. So the answer here is C. Estate at will. It doesn't have a particular time frame. So 3 of the 4 principal types of leaseholds estates are the estate for years, which has a specific lease term from 1 year to the other, the estate from period to period, month to month, week to week, where the lease term of the specific period automatically renews, and the estate at will, which has no specified lease term. The 4th principal type, the estate at sufferance, is a tenancy without consent that therefore also has no specific term. However, the leaseholder has been staying there and causing sufferance to the owner. Well, hi, Joyce Ramos. Thank you. Yes, your answer is correct. Estate at will. Thank you for that. So on the next answer, please type the letter number and the answer. All right, number 42. Excellent. Let's see here. No. 42, almost. Okay, 42. A landlord generally has the right to enter the leased premises. How and when? A, at any time without notice. B, for specified reasonable purposes. C, provided the tenant gives prior permission. Or D, only 30 days prior to lease expiration. So what do you think is a landlord right to enter a leased property? So you own the property, you're leasing. What are your rights to go into the property? Type your answer in the chat. Going once, going twice. Gone. The answer is B, for specified reasonable purposes. So a landlord has the right to go into the properties without notice to the tenant if there's a water leak, there's a fire, or sewer problems, or anything like that where others are complaining or has been notified. So that's considered an emergency. If there's a water leak or there's a fire or power outage and things like that, the landlord has to provide a habitable premises. Therefore, they need to take care of things like that urgently. And sometimes the tenant may not be home, so it needs to be taken care of. Otherwise, they must give a tenant 24-hour notice and let them know via today, text, email, a phone call, or post on the door, whichever is best between them and the tenant. And every state has landlord and tenant laws that typically protect the tenant more so than the owner, because owners are investors and should be more knowledgeable. Number 43, when a tenant rents an apartment, he or she is usually responsible for what? A, compliance with the rules and regulations of the building. B, payment of any alterations to the leased space. C, recording the lease in title records. D, occupying the premises throughout the lease term. What do you think the answer here is? Type your answer in the chat, the letter number and the question number and letter answer, please. The answer is A, compliance with the rules and regulations of the building. And if they have pets, they also have to abide by those rules. Here. All right. Oh, sorry. I was checking to see if anybody is watching on Facebook. It does show that it's live. All right, number 44. Moving right along. Under landlord-tenant laws, landlords must treat tenants fairly and honestly. In a residential leasehold, this requirement would include what? A, ensuring the tenant against loss of personal property. B, providing required building support and services. C, guaranteeing that a fair rent is being charged. And D, insuring the property for the value of the leasehold. What is the correct answer? For under landlord-tenant laws, landlords must treat tenants fairly and honestly. In a residential leasehold, this requirement would include, the answer here is 244B. Providing required building support and services is what the landlord must provide. Right? They've got to provide utilities, a habitable place, no pesticides, heating and air. Well, some places don't require that they provide air conditioning. They could require fans, right? So it depends what area of the country they're in. Oops. Where are we at? Number 45. Okay. 45. While a one-year lease is in effect, what kind of a lease? A one-year lease. The tenant dies of a sudden illness in this situation. So what happens? A, the lease automatically terminates. B, the tenant can record a lien against the leased fee interest. Or D, the tenant estate is still obligated under the lease. So what happens when there's a contract for lease for 1 year that someone dies? Is it forgiven, or the family or someone is still committed? What do you think the answer is? Oops. The answer here is D. The tenant's estate is obligated under the lease. So if they have an estate, they have a will, they have a trust, then they're still responsible, whoever's in charge, the executor or the administrator, to pay the remainder of the year unless the landlord forgives it. Number 46. 3 students rent the house together and all 3 sign a 1-year lease. So how many of them signed the 1-year lease? All 3. 6 months later, 2 students move out. Which of the following is true of the remaining rent obligation? A, the remaining tenant is responsible for the full rent obligation. B, the remaining tenant is responsible for 1/3 of the rent obligation. C, the lease is canceled due to abandonment, therefore the rent obligation is extinguished. Or D, the departing tenants have no obligation have no further rent obligation. So what is the answer here? When there are 3 tenants that signed a lease and 2 of them lease. So the remaining tenant is responsible for the full rent obligation. They need to collect from the other 2 because they signed a 1-year lease, right? That's not kosher. All of a sudden they're paying for 1/3 and the other 2 leave and leave them with having to pay the full rent. That person may not be able to pay, right? If they're not able to collect the rent from the other 2, they are obligated to pay the full rent. Tricky, huh? Well, not really tricky. 47. A tenant transfers a portion of the leasehold interest to another party. What kind of an interest? Leasehold. These are definitions. Transfers. Interest. The instrument that accomplishes this transfer is, so what is an instrument? A deed. B, novation. C, sublease. Or D, reconveyance. So a tenant transfers a portion of the leasehold interest to another party. So what is this? A deed, novation, sublease, reconveyance. Vocabulary, 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 and vocabulary. The answer here is a sublease because the tenant is transferring a portion of the leasehold estate, and that portion is to live on the property. They have the right of possession and use. They don't own it. They have the right of possession and use. So those are transferred to somebody else if it's allowed on the lease, and then it's called a sublease. Landlords have to have an agreement with the tenant if they can sublease it. If not, there is no sublease allowed. 28. VJ enters into a lease for his new store. So it's a commercial lease, right? The provisions of the lease require VJ to pay the operating expenses of the premises, such as janitorial and repair expenses. So operating expenses. So this is an example of what type of a commercial lease. A, gross lease. B, percentage lease. C, land lease. Or D, net lease. So they're paying operating expenses, such as janitorial and repair expenses. It's not saying that they're going to have to pay property taxes or insurance, that type of thing. They'll pay for insurance of their premises inside of their belongings, right? It would be advisable. So what type of a lease is this? So this is a net lease because they're paying certain operating expenses. If it included property taxes and insurance, then that could be called a triple net lease. And if you're not familiar with that, go back and review it in your real estate prep book, or purchase this book, or Google it on the net. So the answer was 248D, net lease. Number 49. A tenant obtains a full service lease. What type of lease? A full service lease, where the landlord agrees to pay all operating expenses in exchange for an additional $5 rent per square foot. Commercial properties are usually rented per square foot compared to residential. Another term for this lease is A, gross lease, a proprietary lease, C, exchange lease, or D, full service net lease. So they're paying a rent to the landlord that agrees, a full service net lease, okay? And sometimes don't let the terms in the question think that that term has to be in the answer also, okay? Because you're probably, it's a trick answer. So they're renting the full service of the lease, commercial lease, in exchange for $5 per square foot. If it's 100 square feet, then it's 500. They're not paying anything else. Everything's included. So this is called a gross lease. They're paying a gross amount, which is $5 per square foot. So it's a gross lease or full service lease. Requires the landlord to pay the property's operating expenses, including utilities, repairs, and maintenance, while the tenant pays only rent. Rent levels under a gross lease are higher than under a net lease, since the landlord recoups expenses outlays in the form of additional rent. So you might say, oh, full service lease. The answer is full service net lease. No, a net lease will include, if it's net, a net or triple net, will include operating expenses on the net lease. This one doesn't. So it's a gross lease, just a gross amount per square foot. Oh, shoot, I didn't type the answer for 248. Or if I did, I didn't show it. So there's 248 and then 249. is A, a gross lease when they're renting just per square foot. They're not paying any operating expenses. When you start thinking of net leases, they're going to be paying some type of expense in addition to rent. Number 50. Which of the following circumstances is the most likely scenario for a ground lease? Okay, a ground lease. A developer wants to acquire a necessary parcel that separates two parcels she already owns. B, an owner-developer wants to retain ownership of the land portion of the improved real property. Or C, a fast food company wants to place a restaurant in an existing building without buying either land or improvement. D, a farmer wants to sell his property to a mining company. So which of the following circumstances is most likely scenario for a ground lease? So an owner is renting the property as a ground lease. What is the answer here? So the answer here is an owner. Okay, so which of the following is the most likely scenario for a ground lease? So the first one says developer wants to acquire a necessary parcel and divide it. B, an owner-developer wants to retain ownership of the land portion of the improved real property. So they retain the land, okay, and so they lease the land. C, fast food company wants to place a restaurant in an existing building without buying either land or improvement. Or D, a farmer wants to sell this property for a mining company. No, they want to keep it as a ground lease. So they're leasing the ground. So the answer here, 250, I already typed it in. So ground lease are primarily used when an owner wants to lease raw land to an agriculture or mining interest when unimproved property is to be developed and the owner wants to retain ownership of the land. Farmers will rent the lease like $100 per acre, just sufficient enough to pay the property taxes. And the farmer ends up maintaining the land, right? Because they plant seeds and then they harvest it and then they have to turn the soil. So that's a great way to own land and have somebody else take care of it until the owner is ready to sell. So the owner wants to retain ownership of the land. When the developer or future users of the property do not want to own the land, or when the owner of an improved property wishes to sell an interest in the improvements while retaining ownership of the underlying land. So sometimes an owner will allow someone to build buildings on it, and they're leasing the land, but the building belongs to the fast food business, or a restaurant or something like that. The owner keeps the land, so they're making money off of a business, and that's a good kind of lease to have, because as long as that person or that owner has a tenant there that owns a building and a business, they're going to continue to have their money paid every month. So these are usually long-term leases, 10, 25, 50, 100-year leases. To farmers, a lot of times they used to do these leases by handshake. They didn't have leases. I have dealt with selling property. I have dealt with helping sellers sell property where they didn't have a written lease. It was a handshake lease. And I had to get both parties, to sign a lease. Back then, the honesty was great, Today, that's challenging. So I'm transitioning. And so those were national questions. I'm now going to transition to state questions for Texas, being that I am in Texas. So if you're from Texas, then you will stay for the next set of questions, which will be on test number 13. let's see here. On page 400. Okay. No. 1331. Yes. Okay. So we're going to do 1331. And here, my answers, because of course I'm the teacher, right? I get to see the answers so that I don't make any mistakes, because I'll make mistakes, right? We're human. All right. So test number 13, let me now share the screen. Okay, so test number 13, let me show you what the topic is in Texas. Oops. So test 13 for Texas has to do with standards of conduct in Texas brokerage practices. So that's what the following questions have to deal with. Standards of conduct in Texas brokerage practices. Oops, wrong. So these are books that I read or books that I have used to teach the class. And I clicked the wrong button. Oh, come on. Open, Sesame. Well, now it's giving me a challenge, so bear with me. Hopefully there, it's going to come up. Yes, there it is. Okay. So we're starting with question 31. And some of these are a little bit longer. So, and minimize the words there. Ooh. Okay, 31. These are Texas questions. All right, so Texas state questions. I'm putting that in the chat. All right, and so when you review this video again, you can put it at a higher speed. I listen to a lot of videos at 1.5 or 2 speed when the speaker is very clear. And I can listen to it much quicker, and I don't have to wait a whole hour. I can reduce the time by 50% or more. All right, a licensee shows a property to an interested buyer, which the buyer likes very much. During the second showing, the buyer reveals that the house was previously occupied by a person who died of AIDS. The buyer blames the agent for not disclosing this fact and threatens to file a complaint to TREC, Texas Real Estate Commission. Which of the following is true? Does it have to be disclosed? A broker has failed to deal honestly and competently with the buyer prospect. B, the broker has validated a duty to disclose unnatural deaths which have occurred in a listed property. C, the broker has jeopardized the client's interest and could face disciplinary action. Or D, the licensee is not required to make any disclosures, or inquiries regarding AIDS. So what do you know about this answer? Must it be disclosed or not? There are certain things that we must disclose, and there are others that are confidential. Anyone going to type in the chat the answer? Okay, the answer here is D. The licensee is not required to make any disclosures or inquiries regarding AIDS, right? Okay, so now we're moving into test number 14 in the book that I show at the beginning, I share with you what book it is by Stephen Metling. It's a Texas prep book that includes national questions and reviews information for all the books that you studied. So this is about Texas agency and brokerage relationships. The other one was conduct. Number 41. I like it when the letters are bigger. Acceptable sanctioned brokerage relationships in Texas. Which of following are acceptable sanctioned brokerage relationships in Texas? A, buyer agency and seller agency only, no subagency or dual agency. B, buyer, seller, and subagency. C, transaction brokerage only. Or D, buyer and seller agency, subagency, and intermediary representation. So what is the answer here? Type your answer in the chat. So in Texas, we do not have dual agency, meaning you can represent both seller and the buyer. The broker can, therefore, we have intermediary representation, meaning the broker, which is our umbrella, can represent the seller and the buyer through one of their realtors, one of the real estate agents. So we have buyer and seller agency. Sub-agency is where the buyer doesn't want to have an agent represent them. So, but they want a buyer agent to write the contract. That buyer agent legally represents the seller and may not share information with the buyer, just as if they were representing the seller. Number 42. Which of the following best defines an agent per Texas statute 1101.557? Don't ask me the terms about that. I can look it up on the answer. So a broker who represents a party in a real estate transaction or who lists real estate under an exclusive agreement. So that is Texas statute, right? Which of the following it defines it? B, a broker who holds a real estate license. C, a broker who sells and leases real estate. D, a person who exclusively represents buyers and sellers in an intermediary position transaction. So 14.2 A is the answer. I didn't mean to say A, but the answer is A. So a broker who represents a party in a real estate transaction or who sells real estate for who lists real estate for sale under an exclusive agreement for a party is that party's agent in that section 1101.557. Note that brokers can sell and lease real estate without being an agent. Also, a licensee can conduct real estate services without entering into an exclusive agreement. Okay, so it says here, note that brokers can sell and lease real estate without being an agent. In other words, they're not being a real estate agent, they're just being the broker. Also, a licensee can conduct real estate services without entering into an exclusive agreement. So they could have an open agreement, or the seller wants to be able to sell it themselves, so which is an exclusive agreement. The other one is exclusive right to sell, meaning no matter who brings the buyer, procures the buyer, the broker, the agent, gets paid. All right, 14.3. So the answer was 2, a broker who holds a real estate license. Is that correct? No, I'm sorry. I typed the wrong answer, like I said. I said the wrong answer. It's a broker who represents a party in real estate transaction who lists real estate under an exclusive agreement. So let me correct 142. I'm going to delete that. It's 14.2A. And should you ever catch me writing the wrong answer, please let me know, because it does happen like right now. Okay, we're on 14.3. A broker in an agency relationship must regulations. A, the broker must present all full price offers to the seller. B, the broker must disclose receipt of all offers. C, the broker must negotiate a seller's listing price. Or D, the broker must refrain from interfering in negotiations with represented principals for 90 days following the expiration of the listing. So what do you believe the answer, what do you know the answer is here? When a broker in an agency relationship means they have a signed agreement, right? As a buyer agent or as a listing agent. So it must comply with which of the following agency-related regulations? Type your answer in the chat if you know it. So the answer here is B. The broker must disclose receipt of all offers and present them. So brokers may not conceal the receipt of an offer or interfere with represented parties prior to the listing expiration. No 90 days in question here. So finally, brokers do not have an obligation to negotiate the listing price with a seller. We do the comparables and show them what the market currently has as to where their property should be listed at. And we don't want to take overly priced properties because it's a waste of their time, our time, unless you want to get your name out there on a sign on that property to attract other buyers and sellers. But it all has an expense. So some realtors will buy listings, meaning they'll accept a really high price listing, knowing that it may not sell or probably will not sell at that high price. Because all owners, including realtors and brokers that own property, we think our property is always worth more than what we're told until we finally hit reality. And we let go of La La Land and hit fancy, get off fantasy land and realize, real price now is based on what's happening in the market. And the last thing is what the seller and the buyer will agree to. That's the final market price. All right, number 4, 14.4. 2 home buyer prospects walk into an open house and start talking to the seller's agent hosting the occasion. They inform the agent that they need help looking for properties in and around the neighborhood. What is the host's responsibility in this scenario with regards to representation? A, the host must give the buyers the seller property condition brochure. B, the host does not have to disclose anything since there is no talk regarding pricing. C, the host must tell the buyers that she represents the seller of the open house property. Or D, the host must complete the dual agency disclosure. Now, we're in Texas, remember? So what do we as realtors in Texas must disclose when we're at an open house and buyers come in and we may or may not represent the seller? So which one is the correct answer? The answer here is C. The host must tell the buyers that she or he represents a seller of the open house property. And why? Because we cannot share any information on that property except for what is public or other comparables. We cannot say, oh, the seller's willing to accept this price, or I can represent you. No, we are a no dual state. Now, if they're not interested in that home and they want to see other properties, then that realtor that holds the open house that represents the seller may represent them if they want representation. And it's our job to be proactive and get their business, right? But serve them and do the right thing for what they need. But we cannot share information about the current house except for what's public. Number 15. No, number 14.5. Which of the following scenarios would require agency disclosure? A, two buyers tell an Austin agent that they are seriously considering moving from San Antonio to Austin. B, a buyer tells a licensee that they cannot live in a two-story home. C, a buyer tells an agent at an open house that they like the listing at the end of the cul-de-sac with the detached garage. Or D, a seller tells an agent that he and his wife are considering downscaling their main residence. So which of the following scenarios would require agency disclosure? 14.5, answer is the answer here is C. A buyer tells an agent at an open house that they like the listing at the end of the cul-de-sac with the detached garage. So which of the following scenarios would require agency disclosure? We disclose that we are a realtor. So two buyers tell an Austin agent that they are seriously considering moving from San Antonio to Austin. A buyer tells a licensee that they cannot live in a two-story home. They're interested in the listing at the end of the cul-de-sac. So here's a communication about a particular property. D, a seller tells an agent that he and his wife are considering downscaling the main residence. So the other three answers do not speak about a particular property. C does. And so then there is agency disclosure that is needed. Got it? Any questions? All right, number 6. In which of the following instances does a broker have to disclose an agency relationship? A, when the broker meets another principal party to the transaction, the buyer's spouse. B, when an agent meets a relative at an open house. C, when an agent has completed a lease with a tenant and plans to meet the tenant the following day. Or D, whenever the agent receives a phone call while performing floor time duty. So when do we disclose an agency, have to disclose an agency relationship? $14.6, the answer is A. When the broker meets another principal to the transaction, the buyer's spouse. So they're already in a under contract or a listing, and the other party spouse comes in, they have to disclose the relationship. Who do they have a relationship with? When an agent meets a relative at an open house, nah. When an agent has completed a lease with a tenant, it's already complete. And plans to meet the tenant the following day, they've already discussed it. Whenever the agent receives a phone call while performing floor time duty, they still don't have a property in mind, so don't disclose yet. However, if ever in doubt, say, hey, I represent the seller, or I am open to represent you. Okay, that one was number 6. All right, number 7. In a given agency relationship, a broker is obligated to disclose to a seller all material information known to the agent, right? Known to the agent. This is an example of A, seller agency, B, buyer agency, C, dual agency, or D, intermediary agency. So with some of these questions, you should already know that one of them is not the answer, and that's C. That leaves you with A, B, and D. right? Because Texas is not a dual agency state. So if they're disclosing to a teller all material information known to an agency, what kind of agency relationship do they have? A seller-agency relationship. An agent who is obligated to disclose material facts to the seller is acting under the duties of seller agency. Such an obligation to a buyer would characterize buyer agency. Okay, they already told you they're obligated to disclose to a seller. So it's seller agency. Number 8. In the last paragraph of the disclosure, information about brokerage services, which we now provide to every individual that we meet. And we include it in our signature of emails, our websites, anywhere that we discuss real estate. In the last paragraph of the disclosure, information about brokerage services, there are several important recommendations made to prospective buyers and sellers. One of the most important of these is that A, whoever compensates the agent is the ultimate party the agent is responsible to. B, whichever alternative is selected, the seller is the party the agent legally represents. C, the consumer must make a decision between buyer and seller agency or using an intermediary. Or D, if the consumer decides to be represented, that he or she should complete a written agreement that lists out the respective obligations of the agent and the principal. So what is the answer for number 8? That is disclosed in the last paragraph of information about brokerage services. So nobody is wanting to participate today. I ask you and I welcome you to participate because it helps you. You're taking a chance and to answer the question. You may get them right. Don't be afraid. This is where you want to participate and input an answer in the chat box. For some reason you get it incorrect, I'll explain why you got it wrong and help you to understand it. And the information about brokerage services, right, we abbreviated as IABS. So we represent the party that could be the seller or could be the buyer. But here they're talking what is in the last paragraph, because this form or this disclosure talks about seller agent, buyer agency, intermediary, and then, of course, the last paragraph. Number 9. 3 of the following scenarios accurately characterize the duties of an intermediary. What is an intermediary? Do you know what that is? If not, please pay attention or go and research it and learn. Which one does not characterize the duties of an intermediary? A, must treat parties honestly, fairly, and impartially. B, must not disclose confidential information regardless of circumstances. C, must disclose information materially impacting property condition. Or D, may not negotiate a lower or higher price without authorization. So what is the correct answer here for number 9? The following three of the following answers accurately characterize duties of an intermediary. Which one does not? The answer is B. B says may not disclose confidential information regardless of circumstances. And that's not true. If it goes to court, if there is legal request and demand then the confidential information will be disclosed. But they must treat parties honestly, fairly, and impartially. They must disclose information materially impacting the property condition. Okay, because a buyer is making an informed decision about that property, and they need to know what impacts the condition of the property, because that'll determine whether they'll make an offer, whether they'll follow through, or whether they need some repairs done, right? And go back to the negotiating table with the seller if they're under contract. They may not negotiate a lower or higher price without authorization. Big no, no, no. Whenever we deal with a seller or the buyer, we're negotiating for them, but with their approval, their consent, and their decision. We don't make the decision. We make recommendations based on data, statistics, comparables, and then they make the decision on our recommendation and proof of what I just mentioned. So 149 was B, may not disclose, and it says regardless of circumstances. Typically, we do not disclose our client's personal information and information about the property. However, if the courts requested there's a legal lawsuit or whatever, then they will be disclosed. And if we have permission from the owner that they say, hey, I want you to disclose that I am motivated, I'm desperate, or, I really, really want to sell it. Get it in writing. Always get it in writing. Number 10. A broker decides to represent both sides of a single transaction. If they proceed to do this, which of the following consequences applies? A, he must act as an intermediary. B, he must represent the seller and get someone else to represent the buyer. C, he or she must obtain the verbal permission of all parties. Or D, since dual agency is illegal, they will be violating licensed law. So what is the answer for number 10? Who can represent both parties and under what condition in a single transaction? The answer here is as an intermediary. The intermediary is the broker, because the broker has many agents, realtors under them, right? We hang our license with a broker unless we are our own broker and we don't want to be with a brokerage. But that requires several years of experience. Every state is different. So when there's a broker, they have realtors. One represents the seller and one realtor represents the buyer. That creates an intermediary situation for that broker, because both realtors are under the same brokerage. Number 11. What is the primary function of an appointed intermediary? A, to stand for the primary intermediary in the event of an absence or illness. B, to give the principals a choice in which broker they may prefer to represent them. C, to represent the principal party that the broker does not represent. Or D, to carry out specific instructions from the intermediary for the benefit of the principal party. So what is the answer for number 11? Again, I invite you to type your answer in the chat. Going once, going twice, gone. The answer is D, to carry out. So the appointed intermediary responsible to carry out specific instructions from the intermediary for the benefit of the principal party. And who's the principal party? The seller or the buyer or the tenant or the landlord, on and on. Number 12, which of the following accurately describes a broker's duties in managing operations? A broker must develop then abide by his or her rules for handling trust funds and managing the trust accounts. B, the broker may delegate compliance duties, but must ensure timely communication between his delegated sales agents and clients. C, the broker may delegate selling and prospecting activities, but may not delegate property management activities. D, all listings in sales agents' names must be maintained to accurately reflect each sales agent's address and contact data. So what is the answer to 1412? A, B, or C? Which of the following accurately describes a broker's duties in managing operations? A broker's duty in managing operations. The answer is B. The broker may delegate compliance duties. Compliance is, reviewing all documentation, making sure everything is dotted, T's are crossed, and so forth. But must not ensure. The broker may delegate compliance duties, but must ensure timely communication between their delegated sales agents and clients. So a compliance department reviews all the legal documents in a transaction and must update the realtors, the sales agent, the buyer agent, in case something needs to be corrected, updated, or different documents, and so forth. Once they approve all the documentation, then we can get paid. Woohoo! Cha-ching! And with many brokerages now, we can do all this information ahead of time. The compliance department reviews all the documentations, make sure everything is accurate and dated, and then send the approval to the title company or an attorney to pay us on the date of close or when the clients get paid. Number 13, and when I say when the clients get, happens on the day of closing, if all signing is done early enough in order to provide the funding and issue all the payments, or it'll be done the next day. If they sign late, then all distributions will be done the next day. 13, a broker must discharge numerous duties relating to her agency relationship. Which of the following is such a duty? So a broker must discharge numerous duties relating to their agency relationships. Which of the following is a duty, such a duty? A, the broker owes customer honest disclosure of the client's financial status and property value. B, the broker owes a fiduciary obligation of fairness and impartiality in all dealings with clients. Or C, the broker is obligated to justify any and all subordinate terminations with a TREC, Texas Real Estate Commission. Or D, the broker must disclose to the principal all known information affecting the client's decision making unless legally prohibited. Slow down there a little bit at the end. So a broker must discharge numerous duties relating to their agency relationship. Which of the following is such a duty? The answer here to 1413 is D. The broker must disclose to the principal all known information affecting the client's decision making unless legally prohibited. So a lot of times we know whatever the seller discloses to us, right? However, we also go and review the property and see with our own eyes, and we may see other things that the sellers may not have disclosed, and we must let them know and disclose it. Because once we see it, we know it, we must disclose. Anything the seller tells us about the condition of the property that may affect a buyer's decision, then we already know it. We must disclose it if it is not in the seller's disclosure notice. By law, we do not disclose. All right, Transactions, listings, and closing files must be maintained from the date of closing or expiration for a total of, so here in Texas, we hold them for how many years? A, 1, 2, A, 1 year, B, 2 years, C, 3 years, D, 4 years. How many years must we retain them here before we shred them? Nobody wants to answer? So the answer here for 1414 is D. We must maintain them for 4 years. Like if you want to get your broker's license, you must practice real estate for at least 4 years and complete a certain number of transactions of all different types before you can then take a broker exam and be approved by Texas Real Estate Commission to be able to take that exam. You can't become a broker just because you want to become a broker. There are conditions to meet, requirements to meet. All right, but we keep documents for 4 years. Number 50, in Oregon, I used to have to keep documents for 6 years. So when I moved here to Texas, I still was storing them. Back then, we stored them in hard copy. Today, we store them on the cloud, on the internet. I use Google, okay, cloud, because I prefer the Google Cloud and Gmail. If you're an iPhone user, you might have the iCloud, but I use Google Cloud. All right, number 15. Brokers are required to maintain office policies and procedures to ensure that, among other things, sponsored sales agents keep current on law changes and their continuing education requirements. CE, right? That's continuing education. Which of the following is not a goal served by policy and procedure manuals? A, advertising compliance. B, proper records maintenance. C, optimized web presence for marketing listing. Google Chrome, hush. Quiet. Google, quiet.
Benefits, health and safety.
Oh my God, that is my
company culture.
My Google Home thing. I should have said, okay, Google, quiet.
Understood. Responding with minimal output.
Okay. All right, sorry. Brokers are required to maintain office policies and procedures to ensure that, among other things, sponsored agents, sales agents keep current on law changes and their continuing education requirements. Which of the following is not a goal served by policy and procedure manuals? A, advertising compliance. B, proper records maintenance. C, optimizing web presence for marketing listings. Or D, ensuring practice licensees have active licenses. So what's the answer for number 15? It's not a goal served by policy and procedures. It's left to us to maintain. So what are you thinking? Are you thinking that it's C, optimized web presence for marketing listings? If you were, that is correct. Ding, 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 ding. I'm going to get one of those machines where I salute you or I reward you by making certain sounds since I go live, right? I can do that. Let's see here. I keep going the wrong way. Hear my frustration. Oh my goodness. All right, it's going to be small. Number 16. In the course of brokerage practice, licensees share or split fees. Which of the following compensation scenarios would constitute a license law violation? A, sharing or rebating a commission with another sales agent with prior broker and principal approval. B, paying a one-time referral fee to an unlicensed party who is not practicing real estate. C, splitting a commission with an unlicensed party who is performing licensed activities. Or D, sharing or splitting commission with a sponsoring broker. So which of the following compensation would constitute a license law violation? Who can we not split commission with? Or I should say, that'll help you answer the question, because we can only split commissions with, I would have said. So the answer here is C, splitting a commission with an unlicensed party who is performing licensed activities. Okay, so A says sharing or rebating a commission with another agent with prior broker approval. Yep. Okay. Paying a one-time referral fee to an unlicensed party is not practicing real estate. So which of the following scenario would constitute a license law violation? That's C, right? But paying a one-time referral fee to an unlicensed party who is not practicing. So we can do like a $50 referral fee, okay, to someone. And that is not licensed, or, well, that depends on the state. Okay, so here in Texas, you can pay a $50, which we sometimes call a bird fee, for helping you find somebody or refer somebody to you. Because, a lot of times clients refer other clients, which is how we want to develop our business. I have a tendency to be a one transaction type of realtor. However, I have clients that keep coming back to me, which is awesome, because I probably did a lot of things right for them and solved their problems, because that's what we are. We are problem solvers and solutions providers, and providing excellent service, the best that you can do with knowledge and continued education for our clients. They will come back. Number 17. As a rule, rebates, commissions, and service provider fees in real estate transactions must be what? Transparent. In that context, which of the following scenarios is in compliance with licensed law? So in order to be transparent now, some brokerages and other organizations have clients sign a disclosure that there might be a commission fee or an affiliate fee or something like that they might receive if a client goes with that particular provider. Kind of like if you're also an affiliate of Amazon or other tools that we use on YouTube or other things like that, we might get a referral, an affiliate fee. So as a rule, rebates, commission, service provider fees in real estate transaction must be transparent. In that context, which of the following scenarios is in conflict with licensed law? A, without the buyer consent, a service provider rendering services to the buyer pays the seller's representative a commission for the referral. B, a licensee discloses and obtains consent from her seller client to receive a fee from a property inspector. C, a licensee accepts a service provider fee that is contingent on the client's purchasing the provider's services. D, a licensee who represents the buyer enters a contract with a service provider to perform services for the buyer on behalf of the provider. So which one would be in compliance with licensed law as to receiving a fee? So remember, must be transparent. So that means what? We've got to disclose, have them sign something. So which one would it be? A, B, C, or D? The answer here is B. A licensee discloses and obtains consent from her seller client to receive a fee from a property inspector. Okay, so it is transparent. Everyone is aware. The client is aware, the seller or the buyer. So the first one says without the buyer's consent. So it's not transparent. C says a licensee accepts a service provider fee that is contingent on the client purchasing provider services, but it wasn't transparent to the client, right? Or D, a licensee who represents the buyer enters into a contract with the service provider to perform services for the buyer on behalf of the provider. Did they disclose it or transparent? No. Okay, so, and that may not be acceptable, all right? It's not in compliance with license law. Don't mix different businesses. If we do, we always must disclose. Please always disclose. Be honest, be straightforward, be transparent. When we tell the truth, we don't have to try to remember what the heck we said, right? Best practice, be honest, sincere. Number 18 is next. 18. Which of the following is true regarding referrals? A, the party receiving the referral must be licensed. B, the referring parties need not to be licensed under any condition. C, the referring party must be licensed regardless of compensation expectations. Or D, the referring party must be licensed if expecting compensation for the referral. Which of the following is true regarding referrals? The answer here is D. The referring party must be licensed if expecting compensation for the referral. So one agent can refer to another agent and put it in writing, and they both must be licensed if they expect compensation. Okay, the party receiving the referral must be licensed. Both parties must be licensed if there are one agent referring to another. Referring parties need not be, and there's money exchanged. Referring parties need not be licensed under any condition. So be very careful. Under what conditions? Any condition. C, the referring party must be licensed regardless of compensation expectations. It depends. Like on the prior question. As a rule, rebates, commissions, and service provider fees. Okay, so this one, our answer on number 17 was what? B. A licensee discloses and obtains consent from her seller client to receive a fee from the property. Oh, that's not the one I was thinking of. In the course of brokerage practice, licensees share or split fees. Which of the following compensation scenarios would constitute a license law? And number 16 was C. Splitting a commission with an unlicensed party who is performing we're on question number 18. So referring party must be licensed if expecting compensation. So the two realtors that are dealing with a referral of a client, either a seller or a buyer, both must be licensed if they're expecting compensation. Sometimes we can refer a client and we don't expect any compensation. Number 19. So let's see what else it says here. I was trying to find one where I said you could do a $50 referral fee. I think it was number 16. In the course of brokerage, licensees share or split fees with the following compensation that would constitute a license law violation. paying a one-time referral fee to an unlicensed party who is not practicing real estate. Okay. When somebody refers us someone, we can give them a gift. Okay. It's not a referral fee. A referral fee is considered from one realtor to another realtor. Providing a rebate or affiliate fee that we must disclose to all parties. But if somebody brings me a referral, I might send them a gift certificate. You don't provide cash. Remember how we can provide a gift? It cannot be cash or a Visa card. It has to be in the form of a gift certificate or a gift, a physical gift, no cash. Number 19. Which of the following would be categorized as an unlicensed activity not requiring a license? A, developing a mail campaign for a new licensee. B, responding to phone inquiries regarding the condition of an open house listing. C, confirming a listing address on the phone. Or D, assimilating recently sold properties into a price strategy for a builder. So which one would be categorized as an unlicensed activity not requiring a license? So this is like for assistants, real estate assistants, or transaction coordinators. So which one would be acceptable activity by an assistant or a transaction coordinator that is not licensed? So the answer here for number 19 is, C, confirming a listing address on the phone. They're not giving any information on the property, just confirming an address when somebody calls in. So developing a mailing campaign, well, they need to have real estate knowledge. The condition of an open house listing, they're sharing details about a property that requires a real estate activity license. Assimilating recently sold properties into a pricing strategy for a builder that requires a real estate license. They're dealing with properties that are being shared to the public, to a builder, to strategize. Their pricing strategy is what works for them. All right, that's the last question for tonight. We did 20 questions for national and 20 questions for state. Any questions before we call it a night? And I want to thank you for participating a little bit tonight and for being here to review national and Texas real estate questions. The more you do these questions, repeat them over and over and over, the better and the quicker you'll be able to answer questions in the actual exam. Remember, if in Texas, we have two exams, the Texas and the national. If we pass both, yahoo! Congratulations, you're in inactive status until you select a broker. If you happen to fail one, only pass one, then you must repeat one course and then retake only that one exam. If you fail both, then you must retake 2 of the 6 courses you took and retake the exam for both. In some states, the national and the state is combined into one exam. So they're only taking one exam. And I've been doing real estate since 2001 on and off. I'm a retired engineer. That engineering was my passion. Real estate is now my passion. Once I gave up engineering, then I started investing and then started practicing real estate full time. Even though my license was active since 2001, I kept updating my license every 2 years. So I had it in Oregon, I had it in South Texas, and now here in San Antonio. When I moved from Oregon to Texas, I only had to take the state exam because I had already passed the national. However, I had to take all 180 hours, right? 6 courses, 30 hours each. Only had to take the state exam, which was nice because national exam is longer. So I'm still an active realtor here in San Antonio, and I practice real estate. I predominantly do residential. That's what I focus on. You know, homes, rentals, land. I love to work with sellers. I do work with buyers. Most of them are my clients or people that I attract from my signs and my marketing or repeat clients. And my thing is to get listings, represent sellers, educate, 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 and do the best that I can do for my clients. And that's why I continue to educate myself, and you should too, because this is just the beginning, okay, of your real estate career. Once you pass your exams, you'll go into inactive status, you'll interview different brokerages. Then now we can go easily into our real estate commission in Texas and select the broker that we're joining once that broker has agreed to accept us, when we agree to go with them. Please interview different brokerages before you select one. See which one works for you. And make sure this is something that you really want to do. We don't know until we get in it, because it is a lot of work. You'll be working 40, 60, 80 hours when you start, because you want to get business. Okay, prospect, lead generate, open houses, or go get for sale by owners, knock on doors, call expired listings, whatever form works for you, or create videos to attract buyers that are moving to your area, or create videos that educate sellers on YouTube. There are many realtors that now have YouTube channels to educate sellers, to educate buyers, or educate real estate agents, educate real estate agent students. I'm now educating real estate agents and students. I have shifted to now include both. So once you pass your exam, keep coming back and watch other types of videos that talk about how to do a listing presentation, how to deal with buyers, how to deal with sellers, what's important in the real estate business, how do you stay and survive in this crazy, stressful business that can make you lots and lots of money when we hustle, hustle, hustle. All right, so anyway, enough of that. So I wish you the best. I want you to pass. Just keep in mind, this is not just, oh, I like doing real estate because I like to go view houses. It's your own business. It's my own business, and I run it the way I want to, as long as I follow policies and procedures of the brokerage and Texas Real Estate Commission and National Association of Realtors. We must follow rules, but you're not tied. It's your own business. You've got to have money to make money, or if not, start working with tenants, with buyers. Hustle, hustle, hustle. Don't be a secret agent. Tell everybody once you're licensed that you're able to help them. And anytime you have questions, post in the comment on YouTube or Facebook. I do reply to all questions. If I don't do it within 24 hours, I will get to them. And I look forward to seeing you next time, and we'll continue the rest of the questions on this book. And other times I may do different types of presentations like some other ones. So I've been doing videos since 2020. And I started doing videos with Facebook prior to that. So I've been doing this since 2014, and then on YouTube since October of 2020. But I did take a year and a half off to focus just on real estate and family health issues. So I wish you all the best. Prepare to study, create a schedule, be consistent, let your family know to give you support, and be realistic about this business, because 87 to 90% drop out of real estate within the first year or the first few months, because it is a lot of work, and you're dealing with a lot of personalities, and we must stay cool, diplomatic, and respectful. Okay, if no questions, until next time, catch you all later. Love ya. This is Lillie Handy Dominguez with Agent Prep coming to you from San Antonio, Texas. Good luck on your exam. See you next time.